The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we're going to hear this morning is Rice versus Adams, and Mr. Kopinski. We'll hear from you.
Good morning, Your Honors. May it please the Court. John Karpinski on behalf of the appellant defendant correctional officers. This case is grounded in the medical treatment that Ms. Rice received during her nearly 13 hours of incarceration at the Cecil County Detention Center. During this brief time, Ms. Rice was seen by qualified healthcare professionals, which are employed by a third-party medical provider, Prime Care, Inc., 3 separate times. Through these visits, the medical staff evaluated Ms. Rice and prescribed a course of treatment.
Those folks are not part of this appeal, right?
Correct, Your Honor.
This is just the sheriff and the sheriff's employees.
That's correct. They are part of the case below, but they are not part of this appeal. Your Honors, we submit that the district court erred in denying the correctional officer appellant's qualified immunity. The court first erred in defining the constitutional right as Ms. Rice's, quote, right to medical treatment for her serious medical conditions. And the court also erred in finding that plaintiff appellee plausibly pleaded a constitutional violation against any of the 16 named correctional
Let me ask you how
officers.
this would work. This is a 12B6, so we're just looking, I know you filed a motion to dismiss or for summary judgment. The court chose to follow the 12B6 course. How do we handle qualified immunity on a 12B6?
Well, Your Honor, the steps for qualified immunity is there a clearly established right, and have they pleaded?
Well, I understand, but it's an affirmative defense, right?
Correct.
And so do we look at the complaint to see whether the defense is precluded, number one, and number two, does the plaintiff have to plead in a fashion that anticipates defenses?
Well, Your Honor, certainly I think looking to the 12B6 standard under Iqbal Twombly is helpful, although not dispositive in the qualified immunity inquiry at this stage. I think yes, I think if qualified immunity is, if on the face of the complaint, if the correctional officer defendants are entitled to qualified immunity, then this court can grant it at the 12B6 stage. So I suppose the answer to your question, Your Honor, is yes.
So continue and take me through how we would look at this complaint. Now, let me grant you something about this complaint. This complaint alleges a generalized constitutional violation, but it attributes it to no one. There is no person who is attributed any given fact in the complaint. It just says this was a person there. So there's a problem there in that regard. That's more of a 12B6 failure to state a claim, maybe. But maybe it can be cured by amendment. I don't know. But on qualified immunity, go ahead and take me through what we'd look at.
Well, I think, Your Honor, you would.
As you're starting to do that, your argument is only on qualified immunity. It's not that the complaint is deficient and fails to state a claim?
Well, I think to Judge Niemeyer's question, the two are interrelated in the sense that I certainly believe it is deficient under 12B6, but I don't believe I can challenge that on an interlocutory appeal, Your Honor. I have to take it. If I'm going to take an interlocutory appeal, I have to take an interlocutory appeal on qualified immunity, which we did. But on the first prong of qualified immunity, they have to allege a constitutional violation. And so, Judge Niemeyer, to your question, to allege a 1983 violation, you have to prove ultimately facts against each individual defendant of personal actions that they took. And as Your Honor recognized, there's not an action that any of these 16 correctional officers took that's pleaded in the complaint. So when looking to whether
there's no action attributed to them. I mean, they basically say the complaint alleges a form of 2 sentences with respect to each law enforcement officer that's identical. They're all just listed identically. What's it, 16 of them?
Correct.
Plus the sheriff. And so we can't attribute, but I'm just asking procedurally how we go about this. If you're right, I mean, do they have to, the district court said they alleged a section, Eighth Amendment or a due process clause violation, wherever you place that.
Sure.
But the next step is, do they attribute it to any of the officers? Maybe some of those officers were simply a guard at the front gate. I mean, we don't know.
Correct, Your Honor. In fact, we don't even know if these officers worked for 1 single second of the 13 hours that Ms. Rice was incarcerated. We
Fair
simply
enough.
don't know.
That's a 12B6, right?
We don't know. But to the first part of qualified immunity, have they alleged a constitutional violation?
But can I go back to that question? You're not conceding that that's limited to 12B6 fair to state a claim, right? Qualified immunity itself, right, to get past qualified immunity, we've said in cases like Langford that you have to identify the act of a given person that, right, passes both steps of qualified immunity. So that's not just a fair to state a claim. That same defect that Judge Niemeyer's identified also makes it apparent on the face of the complaint that they don't survive a motion to dismiss on qualified immunity, right?
Correct, Your Honor, and I know Your Honor sat on the panel in the Langford case. I think that case is absolutely identical to this. It was a medical indifference case. They pleaded against 5 correctional officers and several medical.
So to follow up, Judge Richardson, in your view, Langford resolves this case?
Well, I think it resolves the part 1 step of the qualified immunity analysis, which is have they alleged a constitutional violation? And I think under Langford, the answer is clearly no, they have not. As to the 16 named correctional officers.
So do we stop there then, in your view?
Certainly you could, Your Honor. I think that is the path of least resistance to this court resolving this appeal, would simply to say they haven't alleged a constitutional violation against any of the correctional officers.
So if we reverse on that basis, I mean, why would we need to say anything else?
You wouldn't, Your Honor. I agree that you wouldn't. That would be dispositive of qualified immunity for the correctional officers. So you wouldn't have to reach the clearly established right prong.
Can you go back to Judge Niemeyer's question? And the question he raised, I thought was a good one, and I'm curious your take on it. And that is, because qualified immunity is an affirmative defense, it's not natural to think that we look at the complaint to identify it. And yet, obviously in cases like Langford and a host of others, we do look at qualified immunity at a motion to dismiss. But we do so looking at whether it is apparent from the face of the complaint. Can you help us understand sort of why that's the right way to think about an affirmative defense like qualified immunity?
Yes, Your Honor. This court and the Supreme Court have made clear that qualified immunity questions should be resolved at the earliest possible phase in litigation. So it certainly is not the case that you can't, grant qualified immunity at the motion to dismiss stage. As Judge Richardson said, this court has done it many times before. And the reason that it is important to resolve qualified immunity at the earliest possible stage is this court has said, it's not just an affirmative defense to liability. It also is supposed to prevent government officials from having to incur burdensome discovery, which would affect the orderly operations of government. So, Judge Richardson, my response would be, it should be resolved at the earliest possible stage, which is, the motion to dismiss is generally the earliest possible.
And that sort of seems, maybe it's just the nature of it, it puts plaintiffs in a little bit of a tough spot, right? Because on the one hand, the more information they plead to get past a fair to state a claim argument, the more likely it becomes apparent on the face in a sufficient manner that the court can address qualified immunity at a 12B6. And so maybe that's just a difficulty that plaintiffs face. Is that fair?
Well, I think so, Your Honor, but I also think it helps to filter out cases where there's going to be no finding of liability at all in the case ultimately. So it certainly puts, it's a burden on plaintiff, I would suggest, I agree, but at the same time, it also is going to filter out cases that don't have sufficient chance of a finding of liability against the government officials.
What if the plaintiffs come and argue that they want to amend their complaint? What should our response be?
Well, Your Honor, I think amendment at this stage temporally would be very prejudicial to the correctional officers. This is a 2020 incident. The statute of limitations has long run on this case. Plaintiffs filed within 5 days of the 3-year statute of limitations period. So they had plenty of time to conduct an investigation into this incident. Judge Richardson, as was discussed in Langford, it's not impossible for plaintiffs to get this information.
Do you think we should address that question as an initial matter, or if we were to send this back, is the question of amendment something that the district court would be called to take up on its own as an initial matter?
Frankly, Your Honor, I think the district court could handle it as an initial matter, and we could litigate it under Rule 15 below, whether they should have the right to amend their complaint, given the amount of, what the prejudice is. If the court wants to find that it's overly prejudicial, I certainly would welcome it, but I think it could be litigated.
It's odd to do, given there's no briefing at all on that, right?
Correct. I think it's more properly for the district court to decide in the first instance under a Rule 15 motion.
Well, plaintiff hasn't requested it either.
It has not requested it and didn't request it, hasn't requested it at any time below.
All right. We'll hear from Mr. McDonald, unless you have anything further. I didn't mean to preempt your last minutes.
I think I'm reading the tea leaves, sort of, but if I could just make a quick argument on the clearly established right prong, Your Honor. The clearly established right that the district court found in this case was Ms. Rice's right to medical care for serious medical need. Obviously, correctional officers are not charged with providing medical care, especially when the decedent was under medical care by third-party medical professionals. So we believe that that formulation of the right is wholly inapplicable and sort of inappropriate given the difference between correctional officers and medical personnel. So with that, I will reserve my time for rebuttal.
All right, Mr. McDonald?
Good morning, Your Honors. May it please the Court. Randy McDonald on behalf of plaintiffs appellee in this matter. Your Honor, the trial court 100% decided this matter correctly. The trial court walked us right through its reasoning on why.
Keep your voice up. Yeah.
The trial court walked us right through in its order on why it was ruling that the correction officers were not entitled to qualified immunity in its order. It talked about Ms. Rice's opioid withdrawal that she would face. It talked about how each correctional officer was on notice of that. At this stage.
Why is this case different from Langford?
Sure, for a couple of reasons, this case is different from Langford. One, Langford was a person he acted pro se. He was a person that at any time throughout the litigation could have pointed to the individuals who had denied him his rights. Ms. Rice is not here to do that. That's why we need the discovery process to work us through that. Also, if you look at Langford, when it talks about what's needed in the complaint, it does talk about how it puts plaintiff at some disadvantage, and only that ruling was applicable to the Langford case on the facts of the Langford case. And in another case, it may be appropriate for the court to conduct some discovery.
Well, if we just pick any of the sheriff's deputies or employees at random. I'm looking at page 23, the appendix, Kisner, Chestnut, Kennedy. How do they know from this pleading what it is they're accused of doing, how they did it, where they did it, when they did it?
So the complaint accuses them of having heard Ms. Rice screaming and writhing in pain and yelling to her, shut up. Yes, Your Honor. That's what the complaint alleges.
So can you go to that section? That's paragraph 75. And that's where it actually doesn't say that at all. So let's start with the first sentence where it says that throughout the morning, she was screaming and writhing in pain. It doesn't say that anybody heard her. What's the factual basis for that? Like, this is one of the oddities here is that your client is not alive.
Sure.
And that's obviously a great tragedy. But that doesn't attribute it to any given officer. And I'm sort of curious what the factual basis for that is, in part because I'm most curious about what the factual basis for the next sentence is.
Sure.
Right, which is the custody staff, unidentified, right? That's just whether it's that doesn't even identify that it was a defendant, right? That just says somebody in the custody staff, right? Not even a defendant, told her to shut up. And I guess what I'm most curious about is what is the good faith factual basis that you have for making that allegation? Because if you have a basis for it, then it must be attributed to somebody.
Sure.
And the fact that you didn't attribute it to a defendant suggests to me that this is a misleading statement.
Your Honor, I assure you it is not misleading. And one,
So what's the factual basis
Sure.
for a correctional officer telling her to shut up?
we have had conversations with her cellmate. Her cellmate indicates that there were people throughout the night yelling to her to shut up when she was
you didn't
screaming and
say any
writhing.
of that.
I understand that, Your Honor.
But it is odd then to not identify it as a defendant, right? Like it's sort of generic. It's not even. It doesn't say this is like a defendant said this or the defendants said this. It sort of specifically just refers to custody staff in general, like lowercase, right? Not referring
Right.
to a particular person.
Right, but-
that seems like precisely the point of Langford. You don't get to just say, yeah, somebody. And I know it's hard, like particularly in your scenario, because Mrs. Rice is no longer with us. I get it's really hard. I'm not disparaging that point that comes through in Langford, but really hard is sometimes what you get.
No, Your Honor, I do understand. I'm not sure that I'm quite understanding the question that's on the table right now.
The question is, how you said that the defendants heard her screaming and writhing in pain. And I want you to tell me why, based on this paragraph, I actually have any reason to believe like that.
That they heard her?
That these defendants, not that somebody,
Sure.
right? The cellmate may well have heard her.
Right.
Right? I know that may be based on your representation, but I certainly don't know that from the complaint. And I don't know that any of the defendants heard her, or any of the defendants told her to shut up, or any of the defendants had anything to do with it. That's the rub I'm having, which I think was getting at the point that Judge Agee was trying to get you to answer.
So we know that they heard her screaming and writhing in pain. The reason why you know that is because they responded by telling her to shut up.
And who is they in your sentence?
I'm sorry, the custody staff, Your Honor.
16 of them came down?
And I would admit to you that we, at this point, do not know exactly which ones.
And what
That's the-
constitutional violation is it when they come up and tell her to shut up?
So that's ignoring her medical emergency at the time. She's having a medical emergency
What
at
if
the
they
time.
made a judgment that she was just screaming at them? Maybe her cellmate was kicking her.
But that we don't know right now, and we have to rely
No,
on the
but
facts.
I'm saying, the question is, you don't know it now, but the whole question is whether the officers are immune from the conduct that you're alleging. And the conduct you're alleging is very difficult to discern. And at that point, we not only have to identify a constitutional violation, but then we have to identify that the violation was one of which a reasonable officer in that officer's position would have clearly understood. And it seems to me this pleading doesn't impute anything that I can see to any given officer.
So but it does impute it to all of the officers, Your Honor. And so
Wait, why is that? Tell me why. I mean, does paragraph 75 even say that all of the officers heard her and all of the officers told her to shut up?
it does say the individual custody staff. I'm sorry, the custody staff at CCDC told her to shut up. It does say that.
You suggest that reads that every single member of the staff, and which I presume includes the sheriff, told her to shut up, right? Because that's like wholly implausible, right? Like there's no world in which that occurred.
It's not
Right.
implausible, Your Honor. It depends on the number of times she screamed, how long was she
You
screaming.
believe that the sheriff was in the jail on the early morning hours of August the 29th?
Well, that we don't know at this point, Your Honor.
Do you allege it?
That the individual sheriff, we do not allege that in this particular complaint, Your Honor. But nonetheless, Your Honor, the trial court, in its well-thought-out order, laid out why it was making the decision that it made. It laid out that the officers did not have qualified immunity. It laid out the serious medical
What is
condition.
what do you understand the district court to have said why the officers don't have immunity?
Yes, because as the district court walked us through it.
I thought the district court made one sentence in a footnote, and that was it.
No,
Did it go further?
yes.
Okay.
So looking at joint appendix, page 130. When it talks about while in custody, Ms. Rice suffered opioid withdrawal, a medical condition that posed substantial risk of serious harm. She further alleges that Ms. Rice was booked at
Well,
CCDC.
you allege that while in custody, you allege that the nurses or the care people were in charge of her medical attention, right?
So at the time she's screaming and writhing in pain, Your Honor, my understanding is that she's in a booking cell, not in the detox cell that she was supposed to be put into. So in the booking cell, at most facilities, there's not going to be a nurse in that cell. Most likely in the booking cell, there were custody staff at the booking cell, but not a medical staff person.
But you're asking us to infer all of this, because none of that's pleaded.
I understand, but I do think that
But I
complaints.
don't see the district court addressing the qualified immunity there on page 130.
So the district court does address it in the footnote.
Well, all it says is that Ms. Rice had a clearly established right to medical treatment. How does that tie back to any of these defendants?
Right. The individual defendants, Your Honor, it does not necessarily tie back to them, other than the fact that the district court indicated that the complaint states that it was the custody
Right,
staff that
but
heard her.
They're the defendants. We're not talking about the medical staff. We're talking about the deputies.
Right.
I'm sort of at a loss as to how that one sentence has a nexus to any one of the defendants that you've got in this case.
Right, but so that footnote is footnoted to the paragraph. In the paragraph, the district court lays out its opinion about the plaintiff alleges that each individual custody defendant was made aware of Ms. Rice's condition by observing it themselves, by being informed of her condition by other detainees in the facility, and by being informed by other employees and personnel of Prime Care and CCDC. Thus, Ms. Rice's condition was known and should have been known to each individual custody defendant.
What is it that you think let's imagine that there is such a defendant who had that information and heard her screaming and writhing in the early morning of August the 29th. What is the action that you allege, or even didn't allege, but now want to articulate that officer should have taken? What should he have done?
At a minimum, I think the officer should have checked on her to see what her condition was at the time. Called a nurse, checked on her condition,
Checked on her condition and called a nurse.
maybe called 911, depending on what it is that the officer saw.
And the nurse, we know the nurse was there, we talking about the early morning hours of the 29th, and we know the nurse was there 4 different times, right?
Yes,
So the point you're making is that it is patently unreasonable to have gotten a nurse there 4 times over the course, of what looks like, 7 hours, right? So 4 times in 7 hours. Like you're saying, it's like deliberate indifference to have not gotten the nurse there a 5th time?
it's deliberate indifference to hear her scream, to hear her writhe in pain and tell her to shut up, and then at that time not call a nurse. That's the deliberate
Well, I
indifference.
thought the nurses came. You alleged that, right?
At some point, the nurses do come. I think that
Is there an allegation that the custody staff heard her before the nurses were there?
So we don't know exactly which order it occurred in, Your Honor.
Well, it's sort of important. In other words, you're alleging that the some custody guy heard her screaming, even though the nurses were there, and had to call another nurse or call a nurse again. And the question I would have is, what case do you say that violates the Constitution?
So Your Honor, she's in a booking cell, so she's not in a place where most
I
likely.
understand she's the booking. You already said that, but you've conceded that the nurses were attending the decedent multiple times that morning. And my question is, what case do you have where nurses are attending the prisoner and the officer is held to violate the Constitution because he didn't call again or didn't take different action?
Sure. There's not a case exactly on point there, but I think for the court to accept that analysis accepts a lot of the factual allegations made by the defendants. The defendants are saying that there was a qualified medical provider there. That's not something that's within the complaint, and we have to take the complaint on the four corners of the complaint.
But the complaint doesn't allege that the nurse was there at 2:40, at 8:52, 8:59, and
No.
9:43, and 9:52?
It certainly does do that, Your Honor. But
Right, I don't know, you can disparage the defense, but that's in the complaint.
Right.
That's is the allegation that the nurse was not a nurse?
no. Right
You
now,
said that you didn't allege that there was a qualified medical provider that was there. I totally acknowledge it's gotta be apparent from the face of the complaint. If you didn't include that information in the complaint, then I get it, it'd be hard, right? This is back to Judge Niemeyer's point, but you allege that the nurse was there 4 times over the course of the morning of the 20th.
so I'm not saying that the nurse was or was not qualified. What I'm saying is that nowhere in the complaint is she called a qualified person. What,
She's called a nurse, right?
I understand that she's a nurse, Your Honor. I'm not going to go as far as to call her qualified. That is something that the
You
defendant.
think the guard is more medically qualified than the nurse, so the guard should have questioned the nurse, right? You're a nurse, but you probably don't know enough about medicine. I'm a guard, so maybe I should weigh into that.
I think there are situations where a guard correctional officer will have to do such things.
There might be situations, but when you got a nurse there 4 times for opioid withdrawal, really?
Perhaps, Your Honor, yes, absolutely, for opioid withdrawal. Opioid withdrawal can be a violent reaction to lack of having an opioid in your system. Absolutely, yes.
Yeah, but we're trying to find out what's unconstitutional conduct on the behalf of a deputy sheriff. And you're arguing that the nurses are there attending her, coming there multiple times, and that the officers told her to shut up. Now, we asked what should the officers have done, although it's not alleged, and you said they should have called the nurse, or they should have called 911. That's what you just said. The question is, does an officer have to default and say the nurses are incompetent, or the nurses aren't doing their job? Is that something that is imposed on the sheriff by the Constitution?
Your Honor, it can be. It certainly can be, depending on the
Well,
situation.
what's your case? Give me one case that you're relying on that the custody guys should have known about. That tells them they should have overrid the nurses.
So I believe that maybe ICO stands for that proposition, that you can override a decision, or not just that you can override the decision, but you're here for your own constitutional violation. And certainly telling Ms. Rice to shut up while she's writhing in pain.
What case tells a sheriff, a deputy, that he has a duty to take charge when the nurses are there? Just a case that said that it was unconstitutional for the sheriff to not take an over.
Sure. So depending on the factual situation, Your Honor, I think when you reframe the facts that way, I don't think that there is a case that says that. But I don't think that that's the facts that we have here. So the facts that we have here is that while she's screaming in pain, while she's taken instead of to a detox cell and placed in a booking cell, that she's screaming in pain. And what the facts that we have here is that she's told to shut up, that she's not giving nursing care at
So
that
that
time.
was unconstitutional conduct, even though she is receiving medicine, she was being attended by the nurses, and a sheriff is behind her while she's screaming because she's in pain, even though she's being given medicine for that.
I think that-
And so the sheriff is now acting unconstitutionally?
I think that reads a lot of facts into the case that are not within the complaint, Your Honor.
Well, I thought we were reciting facts of the complaint.
So I don't believe that the complaint says anything about a nurse being present while she's screaming in pain.
Let me ask you, just so I'm clear, the district court's opinion in this case came a year and a half after the decision in Langford. And maybe this wasn't raised below, but I don't see that the district court ever addressed that case. Did it? Was it discussed at all?
I don't recall it being discussed, Your Honor, at all at the trial court. So the only point, Your Honor, I would remain is that the district court decided this case absolutely correctly. Would ask the court to affirm the district court's opinion.
All right, thank you, Mr.
Thank you.
McDonald. All right, Mr. Kapinski, you have a little bit of time.
Thank you, Your Honors. I want to pick up on Judge Niemeyer's question. Is there a case that stands for the proposition that there's a constitutional violation when somebody has seen medical attention, is receiving medical attention, and you know, the inmate is screaming in pain? And I think Langford is the exact case we're looking for. I mean, that is the exact factual situation that occurred in Langford. He was sent to outside medical. He came back, and he continued to complain. And the question was, did he complain that his symptoms were worsening? Ultimately, the court found there was no constitutional violation in Langford. So I would respectfully submit, Judge Niemeyer, the case you're looking for is Langford versus Joyner, and it clearly says that there was not a constitutional violation. And I just wanted to point to, there was a lot of discussion regarding joint appendix in the complaint, paragraph 75. Which is the shut up. I wanted to direct the court to paragraph 9, which comes in the introduction, and I'm going to quote, "Despite their knowledge of her condition and Miss Rice's wailing in pain throughout the night, medical and custody staff did not act to assist Miss Rice and told her to shut up while she winced in pain." So that allegation actually attributes the act of saying shut up to both the medical and the correctional staff, without attributing it to anybody. So, if your honors don't have any questions, I'm happy to stand on my papers.
Thank you. All right, we'll come down and greet counsel, as is our custom, and then proceed on to the next case. Hood, Wilson versus Board of Trustees, and Ms. Ford, whenever you're ready, we'll hear from you.
Thank you, Your Honor. I have a hairline fracture on top of my toe, so I'm going to
Oh, take it easy.
That's why I'm running.
Several months ago, I stumped my toe, and I didn't have a picture taken of it, and it's still bothering me, so I think I'm suffering from the same thing you are.
Your Honor, we're here to discuss the matter that's before you all today, which is whether or not the district court erred in its decision to grant summary judgment to the defendant, Community College of Baltimore. I want to start with the court's statement that the affidavit, the loan affidavit of a Mike Netzer was unrebutted. There was a mountain of evidence in the record that the court simply...
Now that, he's the college president?
No, Dr. Kurtenitis is the college president. Mr. Netzer would have been a decision maker in the decision to promote Matthew Bernardi over Melanie Hood Wilson.
So he was part
He was a
of that-
hiring manager.
He was part of the committee that was,
He was a part of the committee, which also goes into one of the abnormalities. Generally speaking, and there's testimony, that at CCBC, hiring managers are not on a selection committee, especially in the initial phase. They're not even a part of the initial interview. They take part of that process some point down the road. But in this case, we had 2 hiring managers on the selection committee, which is one of the abnormalities that Don Elliott and other witnesses testified to, because the case really is about pre-selection and the fact that 3 men were, and white males, were pre-selected, and the process was structured in a way to make sure that those 3 males received promotions, particularly, and we're talking about the workforce development position. There were 3 assistant dean positions, and let me slow down because I'm talking rather fast this morning. There were 3 assistant dean positions. One of them was for, it's called Workforce Solutions, but it's really workforce development. And Matthew Bernardi and Mrs. Hood Wilson were going head-to-head on that
Why don't you
decision.
take us just briefly through what you believe was the process? I thought they went through an interview process, and they had 14 prescribed questions that they asked, and then the various people graded those interviews, and then they got together and came up with composite scores. Is that all?
Well,
You can correct it.
The process itself, on its face, seems normal. There was a search committee assembled. Usually, there's a search committee, and they, try to look for people to apply.
And the search committee was fairly diversified, wasn't it?
In what way? The search
Sex and gender and race.
Well, there certainly was one African-American male on the search committee, but
And there were males and females on the committee too, right?
none of them had program experience
I'm just talking about, it seemed like well, go ahead.
Well, let's take a step back, because yes, on its face, it looks like all things are square. But then for those who have knowledge as to how CCBC works, they understood from the beginning that things were very, very odd. For example, the decision to restructure or reorganize continuing education was exclusively done by Louise Slezak. And she was the one who decided we're going to create 3 assistant deans. We do have the testimony from Karen Paris that Mr. Netzer was aware of this and said that they wanted to create 3 positions so that certain people didn't leave the college. And that they needed to pay them more money.
Just so, I don't want to slow you down too much, but tell me what the JA I look at for your conclusion that it was not Netzer, but instead Netzer that decided to create these 3 positions?
It's in Louise Slezak's testimony, her deposition testimony. She structured the reorganization, her and Matt Lang. That is, the first page of her deposition testimony is at JA 691, and I have to locate the pinpoint site about her decision to reorganize and create the 3 positions. But
But
it's,
she had the
it's-
authority herself to do this?
no, the department was her department. She ran that department. And so there was a decision to reorganize, but she was the one that decided or determined, she says that she spoke to Matt Lang, who was her peer, about reorganization and what that would look like. But they had already spoken with Metzer about
How is any
it.
of this relevant?
Well, then thank you for asking that question. The initial question or the evidence in the record establishes that the process, even the search committee itself, which I think the first question came from Judge Niemeyer about the interview questions and the process, and isn't this a normal process, and did we have a diverse committee? On their face, yes. But the testimony shows that the decision was already made as to who was going to get the 3 positions before Mrs. Hood-Wilson applied, and that because she was more qualified than Mr. Bernardi, they had to rig the process in such a way, or the process was rigged in such a way, to ensure that Matthew Bernardi would get that position, not Mrs. Hood-Wilson. And this goes to the interview questions and the selection committee. Don Elliott
So
testified.
who had the final decision authority here for these? Was it the college president?
Mike Netzer would be the final decision maker, but the committee,
And
I think
he was-
Appelli
he was
concedes.
what?
He was the
Vice President?
I believe it was the vice president of continuing education, if I'm not mistaken. So he was the direct supervisor of Louise Lezak.
Can I just go back? Because when I look at 659, and maybe Judge Agee's right, just doesn't matter. Mr. Netzer says that he's the one that created the 3 assistant dean positions. And so on reply, I would love for you to tell me what evidence you have that contradicts that statement, right? He says it very clearly. I created 3 assistant dean positions to lead each of those units. And so I just want to reply, you gave me the beginning of some testimony. I'm just saying, when you come back up on reply.
Sure.
Will you give me whatever it is you want me to look at that contradicts the express statement of Mr. Netzer?
Thank you. So back to the search committee. So we have testimony from Mr. Elliott, who also served on search committees prior to this, 4 dean positions, to be clear, that the search committee was oddly chosen. And number 1, hiring managers are not on the committee. That would include Slezak and Netzer. So generally speaking, those aren't on the committee. But if what Ms. Hood-Wilson has pleaded is true, they were on the committee to ensure as well that Bernardi would receive that position. The second thing is the administrative assistant. There could be an admin assistant there to provide administrative support to the search committee. However, we have testimony that it is almost never the case that the administrative assistant of a hiring manager is on the search committee.
And
That would have given Bernardi, out of the 5 votes.
Okay, you're eventually going to get to telling us how any of this relates to the errors you say the district court made.
Well, this was evidence in the record that the district court didn't consider. The abnormalities in the process, and I will say the court did come down with a decision, I believe it was in August of this year, the Hollis decision, where the court said, look, deviations from policies and procedures are evidence themselves of circumstantial evidence that could give rise to an inference of discrimination, particularly in hiring
Right, so
decisions.
what would be very helpful to us is if you could very specifically tell us, this is what the district court did wrong, and here's where I'm pointing to the record to show you what it did was wrong.
So the district court erred in its conclusion that Ms. Hood-Wilson did not have a prima facie case of discrimination. And specifically, the district court did not consider the record evidence of Tanisha Ritten's testimony, Jarena Lloyd's testimony. It passingly cited to Don Elliott and Karen Paris, but we have specific information from, and evidence from Mrs. Hood-Wilson and these witnesses that, number 1, Slezak bore discriminatory animus towards Black employees, specifically Black female employees. We have evidence from Tanisha Ritten about Slezak's hiring practices and a tendency to promote lesser qualified white employees over more qualified Black employees. That is a practice at CCBC, even outside of Slezak. employees had testified, and it's in the record that this is something that
So
has
even-
happened.
Let's just assume that we were to agree with you that there was a prima facie case. Then what?
Well, then, if there is a prima facie case, then the case has to be remanded back to the district court because of the fact that the court specifically said there is no prima facie case here. But obviously, the next question would go to pretext and whether or not pretext, whether or not Ms. Hood Wilson had evidence to show that this notion that Bernardi was somehow more qualified was pretextual, and she definitely does. We had more than one employee provide testimony through deposition and affidavits that this process would.
If the court was, even if the court erred on the prima facie case, why would it have to go back if there was no error on pretext?
Well, there was certainly error on pretext
Well,
because
I
the
know
cour-
you say that there is. I'm asking the conceptual question. Because you said just before, well, if the district court erred in saying there was no prima facie case is over, has to go back. So what I'm asking you is if there's a separate finding that we found was correct, that even if there was a prima facie case, there was, that there was no pretext, I'm not sure why the case would go back. This is a conceptual question, not necessarily directed to the facts of your case.
Well, Your Honor, and let me not overspeak myself, that in the case, in our case, the district court found that there was no prima facie case. And obviously, we disagree with that, and we know that that's wrong. And I think even on the issue of pretext, though, we know that there's evidence in the record that establishes that the CCBC's explanation is pretextual. Generally speaking, we do have evidence of the difference between Mrs. Hood Wilson, the way she was treated, and her white comparators were treated. We also have evidence of failure to follow internal practices and deviations from policies and practices, and direct testimony from employees that it was known that Bernardi was pre-selected for this position, and not just.
Can you help me on that point?
Sure.
We seem to have a couple of cases, Anderson from 2005 and Blue from 1990, that both say that pre-selection is not sufficient to find pretext. Why does, so A, can you help me understand why I should ignore our binding precedent on this point? And then B, why does it make sense to think that pre-selection is evidence of pretext? I mean, almost every government agency that I have been involved in, there's some degree of pre-selection that is happening, right? Sort of the people look at the internal candidates and they're like, there's likely to be that person that's gonna be the one that gets hired. We're gonna go through the process, and if it turns out we're wrong, fine, we'll hire somebody else. But you know, there's always sort of some sense of the next supervisor in the U.S. Attorney's Office, we're gonna go through the process, but it seems likely it's gonna be, you know, Sarah over here. I don't understand why pretext is, why pre-selection, as you describe it, is any evidence of pretext or discrimination.
Well, it's not that by itself. We want to look at the context here. So, and I wouldn't say that, I'm not conceding that pre-selection in and of itself can't provide that, provide that evidence. But I do want to look at context, particularly in this case, where we have proof that people have said that Bernardi, and specifically on the areas that Mike Netzer said he was strong, other employees have said, actually, he's not. We've witnessed him fail to admit.
Is that the critical piece? So would we have to find that your client is more qualified than the person chosen in order for pre-selection to matter?
No.
Because you keep saying she's more qualified. I think you understand that, like, we don't do that, right? Like, entities get to make their own judgments about who's more qualified. And the fact that your client thinks that she's more qualified, like, doesn't get us anywhere, right? We should look at the apples, they looked at the oranges, they get to pick, right?
The court is not in the super personnel, you guys are not another personnel committee, but decisions have to be made lawfully, and the case law establishes that. Decisions cannot be made on the basis of discrimination. And so here, it's been alleged that it wasn't just, pre-selection alone. We do have in the record discriminatory comments. We do have hiring practices that often promote lesser qualified white employees over black employees. We also have the fact
but
that Ms.
that's
Slezak was influential over the decision maker in this case,
Those
if not.
observations are so generalized. In other words, you're talking about a workplace that has some people making inappropriate comments.
No,
The question is-
not some people,
The question is,
respectfully,
the
Judge.
decision maker here, Netzer, is the decision maker, and so there has to be, he gets a recommendation from the committee who is engaged in a scoring process, and.
A scoring process that was.
Your candidate came out at the bottom of the scoring process.
Because the scoring process was created to ensure that she came out at the bottom, Judge. Respectfully, that's what the candidates and other witnesses had attested to, that the questions here weren't geared towards academics or program development or program growth or program enrollment, and those are all the things in the record that a
We
director.
should have cared about, right? That you think the committee should have cared about those things instead of other things, right? But then you just want us to be a super personnel committee.
No,
This is
no,
your point.
Judge.
You're like, no, we really should care about these things, not the things that the committee cared about or that Netzer cared about.
No, and Judge,
Right? Like, I'm not a university administrator. Like, I don't do that.
no, but the court should care that decisions are made lawfully in accordance with the law, and I'm running out of time here.
What
but I
question do
think-
you think was discriminatory?
Well, it's, again, the questions themselves could appear, again, superficially not discriminatory
No,
per se, right?
They appeared to go to particular qualifications for the position that they designed.
But they didn't, and there's testimony in the record that the vacancy
You have to
announcements
look at the
themselves.
questions. You just look at the questions, right?
No, Judge. The vacancy announcements themselves were actually drafted towards the position descriptions of the pre-selected individuals to ensure that Mrs. Hood Wilson would not get that workforce development position. The questions, the entire process, when we look at the whole process, the totality of that process was geared to pick a white male over a more qualified black female. And it is the district court still ignored the testimony from witnesses to say that, one, people knew that this was going on at the college. Two, they also knew that Slezak was influential on that committee because this is really her department. And even in her deposition testimony, she stated that the position descriptions, the interview questions, she waffled a little bit on the interview questions, saying, well, we all created them,
Why
but.
don't you help us out when you come back up and identify a specific question that you say was discriminatory?
Your Honor, I don't think that a specific.
On reply.
Yeah.
Okay, thank you.
All right. We'll hear from Mr. Jackson.
May it please the court, my name is Vincent Jackson, and I represent the appellee, the Board of Trustees of the Community College of Baltimore County, which I'll refer to simply as CCBC during this argument. This is a straightforward relative qualifications case. The record shows that CCBC used a documented, fair interview process and an objective scoring criteria to select the best qualified candidate to be the Assistant Dean of Workforce Solutions. Nothing in Title VII or Rule 56 requires a court to second-guess that kind of professional judgment. The district court looked at all of the appellant's evidence and drew every reasonable inference in her favor. Even then, there was no triable fact showing that the college's decision was motivated by race or gender discrimination. This was why the district court properly granted summary judgment, and it is why this court should affirm the district court's decision. Matthew Bernardi was the individual who was ultimately selected to be the Assistant Dean of Workforce Solutions, and the record evidence demonstrates that he was by far the best candidate for the Assistant Dean position. So what was most important for this Assistant Dean position? Well, we have that in a record in the job description at Joint Appendix 650. It's managing a large budget. It's managing a large number of people. It's knowing how to deal with millions of dollars of grants. It's having knowledge of WIOA, which is the Workplace Innovation and Opportunity Act.
But your colleague on the other side says, you're right insofar as it goes, right? That the description met your preferred candidate perfectly, but she says that you should have instead cared about other things, and that the only reason that you cared about the things you did was because that was what the white candidate was better at, and that you should have cared more about the things that her client cared about. Help me understand what's your response to that argument? You're just saying, well, he fit the description. I don't take her to really disagree with that, or doesn't significantly disagree with that. What she's suggesting is that you rigged the conditions to favor the white applicant over the black applicant. And I'm curious what your response to that argument is.
Yes, Your Honor. I think it's important to note that at the time, Vice President Netzer, who was restructuring this department, was figuring out what the assistant dean positions were going to look like. And when he designated these 3 new assistant dean positions, right, he had no idea who was ultimately going to apply for these positions, right? At that time, he posts the announcement. Ms. Hood-Wilson announces that she's going to apply for that. But no one at the college, there's nothing in the record indicating that anyone at the college had any indication that Ms. Hood-Wilson was going to be applying for those positions. I think there's a fundamental tension that's inherent in the appellant's position, and it's this. It's that the college took every step to ensure that Matthew Bernardi would be the person selected to be Assistant Dean of Workforce Solutions. Tailor-made this so that it would fit him like a glove in hand. But by the same token, Mr. Bernardi is absolutely unqualified for this position. He has no business holding this position. He couldn't manage grants, he couldn't do this, he couldn't do that. And those two things, they are contradictory. They cannot both be true. And I think that's sort of the cognitive dissonance that underlies much of the appellant's case that was evident on the record before the district court. And that is one of the reasons why the district court's decision should be affirmed here. So Mr. Bernardi met those qualifications. There is no material dispute of fact that he met those qualifications. Judging by his resume, judging by the fact that when he was Director of Connections to Employment prior to becoming the Assistant Dean, he had to manage a large number of people, 28 full-time employees, 17 part-time employees, and 110 adjunct faculty. That was comparable to the roughly 60 full-time employees, 30 to 50 part-time employees, and 110 adjunct faculty that he actually managed as Assistant Dean. So that was very important for the position, and it was something that Mr. Bernardi was ably qualified as. Now, this case is unique in that, as the court is aware, at Joint Appendix 669 through 671, we actually have a scoring matrix that gives us insight into the selection committee, how they're grading each individual applicant based upon the scores for the 14 questions that were designed for this application process. So we have insight not only into how the selection committee as a whole is viewing this, but how each individual member of the selection committee is grading each applicant. So we've got a finely grained scoring matrix.
Go back and remind me, who selected the questions?
The questions were part of the committee met, they helped come up with the questions, and they eventually settled on the 14 questions.
So it was a committee decision
Yes.
as to the wording of the questions?
Yes, Your Honor. And in arriving at these questions and in going through this impartial process that is meant to ensure fairness, Mr. Bernardi, at the conclusion of it, he scored 285 out of a possible 350 points. The appellant scored 181, over 100 points lower than Mr. Bernardi. This simply reiterates that Mr. Bernardi was far more qualified. Interestingly, Louise Slazak, who was the appellant's direct supervisor and who was the assistant dean and who served on the committee, she's been portrayed as the villain, right, who sought to torpedo appellant's chances of getting this job. Well, Ms. Slazak, you can see from the record, Joint Appendix 669, she gives appellant one of her highest scores among the individual members. She gives her a 38. The only person who gives appellant a higher score is Vice President Netzer, who gives her a 39. This is in contrast to the score given by Mr. Ken Buck, the African-American male who sat on a committee who gave appellant a score of a 35. Mr. Buck, as it happens, was deposed in this case, and upon being asked if he believed that race or gender played any role in this promotion decision, his answer unequivocally was no. That's in the joint appendix at 1078 and 1079. Now, it's telling, I think, that appellant failed to depose Mike Netzer. That's certainly unusual in a failure to promote case where we have a decision maker who's identified in CCBC's answers to interrogatories, and we thank the panel for permitting us to supplement the appendix with our answers to interrogatories to reflect that fact, because it was not raised for the first time until this appeal.
So Netzer was the one who made the final decision.
Absolutely, Your Honor, yes, that was all on Netzer. Netzer was not deposed. The appellant had the ability to depose anyone in CCBC leadership. She could have deposed the president. She could have deposed the vice president who oversees human resources. She could have deposed the director of human resources herself. She could have deposed the other two members of the selection committee who we never heard testimony from her. She could have taken even the 30B6 deposition of CCBC, but she declined to do any of that. Instead, she relied on evidence from Don Elliott, who was actually a co-applicant for the same position, the Assistant Dean of Workforce Solutions. And judging by the scoring matrix on Joint Appendix 669, if Mr. Bernardi hadn't applied for this position, it may well have been Mr. Elliott who would have gotten a position based upon his scores.
What's your response to your colleague's suggestion that there are all these procedural irregularities with this process, that they put people on, she gives a couple of different examples, administrative assistant, department folks, that were not permissible members of the hiring committee. What's your response to that?
A response, Judge Richardson, is that there were no procedural irregularities whatsoever. The only evidence that appellant adduced of procedural irregularities was taken primarily from the deposition of Don Elliott. As I was saying, Don Elliott was one of the applicants to this position, so he was certainly not in a position at all to judge
So your response in part is she has not shown that there were any irregularities under the regulations of the college at the time.
Exactly.
That if there had been, for example, a rule that said whatever it might have said, and they violated that rule, that might be a procedural irregularity that's relevant. But an irregularity that is based on this is not the way things have normally been done is not an irregularity.
That is correct, Your Honor, and particularly when that testimony that this is not the way things have been done, it doesn't come from anybody in college leadership, it doesn't come from anybody on a selection committee, it comes from employees, right? And in some cases, low-level employees, right? Not to diminish them, but part-time adjunct instructors who have no direct personal knowledge of anything that goes on in the selection committee and are relying on pure speculation to get to that point. And these are the two affidavits that my colleague referenced that the district court did consider, did give credence to, and still found that there was no material dispute of fact. Now, under these circumstances, right, the appellant, and I know there's been some talk in this circuit and with Justice Thomas's concurrence in the Ames decision this past February about McDonnell Douglas and the continuing relevance of that shifting burdens of proof and that whole framework. And I think what's unique about this case is that whether McDonnell Douglas, whether that analysis applied, whether we just did a straight Rule 56 analysis, is there any dispute of material facts sufficient to send this case to a jury? The answer in both instances is no. It doesn't matter which evidentiary framework you use at summary judgment. So the district court correctly held that the appellant failed to establish a prima facie case. This was on the...
So what happens if we just assume, for purposes of argument, thought there probably was enough to say there was a prima facie case pled, but that wouldn't end the case.
What would still happen, even if there was a prima facie case pled, the district court was anticipating this and did a thorough analysis and said, well, look, even if a prima facie case was pled, she still went on to analyze the legitimate non-discriminatory reason that CCBC proffered in response to the prima facie case, and then she analyzed whether the appellant could
And that,
establish
I think,
pretext.
in your view, is sufficient at this stage for you to prevail.
Yes, so we would submit that even if this court were to decide that the district court erred in holding that there was not a prima facie case, we would still go through the remaining two steps of McDonnell Douglas, and the district court properly analyzed those as well, and it would still be grounds for affirming the district court because this was a straightforward relative qualifications case. Appellant concedes that no court sits as a super personnel department, and there has not been a shred of any evidence in this record that ties any racial or gender-based discriminatory animus to the selection process or to Vice President Mike Netzer, who was tasked with making the final decision and who could have rejected the decision of the committee, but did not. So even crediting every inference in appellant's favor, like I said, nothing in this record ties race or gender to the college's decision. The district court did exactly what Rule 56 requires. It accepted the appellant's version of events, viewed every inference in her favor, still found no evidence that race or gender played any role. This is not a failure of the district court to see the facts. It is actually a recognition that the facts, even taken as true, do not show any unlawful motive here. Title VII requires proof that bias actually caused the challenged employment action, the failure to promote here. We don't have any proof of that. When a public institution follows a fair process and the record shows that there is no discriminatory cause, summary judgment is not merely warranted, it is justice that is consistent with Title VII itself. For these reasons, we would ask that the judgment of the district court be affirmed, and unless the panel has any more questions, I'll reserve on that.
Thank you, Mr. Jackson.
Thank you, Your Honor.
Ms. Ford?
Make sure I can see names. To start off with by answering Judge Richardson's question about the creation of the structure on page JA 931, that is Slezak's testimony. She actually testified that she didn't know who made the decision to create the three positions, but then I asked, I should say internally first, was the decision made by all of you to say this is the route we're going to go? And she said, yes, I believe so. Everybody was in agreement, rather than keeping it the way it was, that we take advantage of the vacancy that was of Kent Smedley and focus our efforts on having three different divisions, three different.
So when you said that she did it and not Netzer, that's not true.
I was incorrect by saying that it was she, but it was their decision to go, to create the three positions, and then he adopted that.
So your position is that when Netzer says directly, I did it, that is contradicted by testimony where she says, I don't know who created the position.
No, Your Honor, I think that I misspoke there. I think the decision, she decided how it would be structured, i.e. Assistant Dean of Workforce Solutions, and Assistant Dean of Allied Business and Health, and she was involved in that detail. But the decision to create or adopt, three assistant deans versus having to replace Kent Smedley's position, that decision had to be made by the vice president, but she was the one that designed the structure. It's in her testimony.
Where's that?
So again, at page 931, and it goes on.
Is there anywhere other than 931? Because 931, I don't believe says that. And so I'm just trying to understand, is there anywhere else that we should look at where it says that she's the one that designed the structure?
Well, Your Honor, I believe if I'm looking at line 11, yes, I believe so. Everybody was in agreement that we would do, rather than keeping it the way it was, we'd take advantage of the vacancy and focus our efforts on having three different divisions. Then she goes on to say, and I asked, were there only two of you on?
Right before that, though, at some point, the decision was made to create the three positions. Who made that decision? I honestly don't know. I would imagine the president.
Well, and that's what I corrected myself with Judge Richardson when I said that I think the question was who created the positions. And Netzer's affidavit, he said it was
Right.
Netzer. I said it was Slezak, but I needed to correct myself to say that her testimony said she didn't
But
know.
there's nothing there that talks about the selection structure. This
I'm
is just-
sorry.
This is just the notion,
That's-
she chimed in to the 3 positions that somebody else created, which she assumed was the president.
Correct.
That's all she testifies. I'm looking at 931.
Yeah, that's what she's talking about here, and then she goes on to talk about the different backgrounds in which what each assistant dean position would do. But that doesn't refute the testimony.
So tell me where I'm supposed to be looking. It says that she chose those things, that she's the one that created the structure. You said
Well,
she goes on and she does this, but like,
So on the
give me
next,
where I'm supposed to read, because I have some doubts about whether
Okay.
what you're telling me is actually in the record.
okay, so on the next page, Your Honor, Judge Richardson, she's discussing the programming and what went into the programming and how the programming was delineated. And I don't want to use up all my time on that because I have to get to some other issues, so if you don't mind, and I'm happy to stay where you want me, but I
You're welcome
just.
to take your time wherever you'd like to, ma'am.
I just want to make sure I'm hitting some of the issues or the questions that were also asked by some of the other judges as well. I think the focus is on whether or not there's a triable issue here in this court. And Judge Richardson, I believe it was you who brought up Anderson and the notion that the court isn't, second guessing decisions. But as long as those decisions are lawful and made on a lawful basis. And the court addressed this squarely in Hollis by saying, look, even pretext, if we look at that, that there is evidence, and the court pretty much, and it's the same judge, that used the same language in Hollis that she used here, saying that the record was undisputed, but the court said, listen, when we do see deviations from process, and I think, Judge Richardson, you asked the appellee whether or not there's a policy deviation. But in Hollis, I believe the court made it clear that even if it's practice, or certain procedures that the college is accustomed to using, that deviations themselves can be inferences or give rise to an inference of discrimination sufficient for a jury question. And that's what we saw here. And that's what the testimony in the record shows, that it wasn't just the composition of the search committee, but even the interview questions, which we have testimony from witnesses to say that this, literally Don Elliott said he would look at a question and say, okay, that's the Matt Bernardi question.
Yeah,
That's
but see,
the
that's
Steve George
not
question.
discrimination. That's just identifying, there may have been an identification that Bernardi was well-suited for the job because he had managed big programs and a lot of people.
But taken together with the discriminatory comments, too, that we have in the record, made by Ms. Slezak about not just Ms. Hood-Wilson, but specifically to Ms. Hood-Wilson.
So what do you say to the response that she gave your client one of her best scores?
I don't think that matters when the process was designed from the outset to make sure that Bernardi, and if we're talking about the workforce solutions position, that Bernardi was the one selected and that she wasn't based on gender and race.
Your information to us is page 932 is where you think she says that she designed that process. Please
No,
design the
that's, the
process.
question was different. I understood your question to be about who created the three vacancies.
All right.
That's what I understood your question to be, so if I misunderstood it, Judge,
We've gone
I'm
through
sorry.
the red light and,
Oh, sorry.
no, and we've given you a little latitude there.
Thank you.
Yeah.
I appreciate the latitude I was given.
Will, can you go ahead or you want me to?
First take 3 minutes.
Okay. We'll come down and greet counsel and take a short recess.
This honorable court will take a brief recess.
Please. All right, next case we'll take is Trowernick versus Genworth Financial. And Mr. Scalia? Familiar name.
Good morning. May it please the court. In the class certification order under review in this case, 2 former Genworth employees who are also former participants in the Genworth retirement plan were permitted to bind thousands of active employees and Genworth retirees and their retirement accounts to a far-fetched legal theory that has been rejected by the majority of courts to ever consider it. On top of that, this occurred to these thousands of retirees and employees without notice, much less an opportunity to opt out. This violated Article 3 of the Constitution and Rule 23, and to fully appreciate why that's so, it helps to examine the particular nature of this BlackRock target date fund in which they were invested. Always in class certification review, we focus on the facts and the record in that case at hand. Here, what you had is so-called individual account plans. Each Genworth employee and retiree has his or her own account. And these accounts were in a so-called target date fund.
These are all defined, this is a defined contribution plan.
That's correct, a defined contribution plan with those individual accounts. And it's a particular kind known as a target date fund, which actually consists of many different sub-funds or so-called vintages. Each vintage is targeted to a particular retirement age, and over time, the assets in that vintage change. They evolve to a more conservative position at the time of retirement. The result of that is important in 2 separate ways. First, what's in any particular vintage at any particular time varies from what's in other vintages that are targeting different retirement dates and might be more aggressive because it's a distant retirement date or more conservative because it's close. And then second and related, even within any particular vintage, how that vintage performed and whether somebody's account went up some or a lot. And by the way, there's no allegation here that accounts went down. That depends on when they entered and when they exited, because at what particular point along the lifeline of that fund.
What is the nature of the injury you understand to be alleged?
Well, the allegation by plaintiffs here, which, by the way, is extraordinary, and I'm not aware of another court of appeals to consider a case like this. The allegation is that Genworth, even though it had one of the most highly regarded target date funds in the market, should have looked around and realized that at some cherry-picked period of time that plaintiffs found, there were a couple of other funds out there that were doing even better, and they're alleging it was a fiduciary breach to stay with one of the most highly regarded target date funds in the market, which, by the way, had inflows, increased investments throughout the class period. They're saying that should have been dropped. Essentially, they're saying sell
For our
low.
purposes today, we don't need to resolve the question of whether it's a passive fund or an active fund, where the American fund should be the right comparator to resolve the questions that are before us.
That's correct, Judge Agee. We certainly, the plaintiffs themselves have said that you should disregard the American funds and their use of that later on summary judgment in ruling on class certification. And remember, on the class certification motion, they put forward 4 alternative funds, just as they had in their complaint. The American funds was just one of those. They did not base their pursuit of class certification on the American funds. That came later. Now, the use of the American funds as a comparator is in the teeth of the decisions of every single court of appeal to consider this issue.
Can I ask a question about this, the sort of sequential argument? They seem to be arguing, or at least giving them the most generous version, is that there's a breach of duty with respect to the BlackRock TDF, and that comes temporally before the question of what might be an appropriate comparator. The comparator might help us establish damages in some context. But the breach, this failure to monitor and the decision to retain, is actually like upstream of the comparators. Is that the right way to think about their alleged breach of fiduciary duty? And I ask this obviously because of commonality, right, is where I'm interested.
I think not entirely, Your Honor. I
Okay,
think
why-
their
why am I
allegation.
mistaken there?
Because most of the cases that were brought on the same legal theory were dismissed on the ground that the other funds identified in the complaint were not so-called reasonable benchmarks. They were not appropriate comparator funds.
I get that. I get the other cases have done it, but maybe hypothesize that those maybe got it wrong, right? So the question I'm asking is conceptually, why the breach of fiduciary duty, right? Imagine they just went to sleep. They didn't look at anything. They could breach the fiduciary duty even if it was a home run, right? Now, there might not be damages, right? But the breach seems to be upstream of the question of like, what should they have done instead?
Well, a couple responses to that, Your Honor. First of all, part of their allegation is that the market itself was not being properly examined to determine whether these BlackRock funds should be retained relative to what else was going on in the market. So this comparative exercise is they're saying was part of the fiduciary responsibility that was breached. And then second, Judge Richardson, we would maintain that injury actually is necessary to the breach. No harm, no foul in this context is what we would argue. What's critical to understand here is not simply the huge variations in these individual accounts and how they performed in different vintages and over time, is again focusing on the allegations made in the class certification paper. As much as 42% of the assets that were held in the BlackRock TDF funds actually would have done better staying there, staying with the BlackRock TDFs, rather than being invested instead in the most comparable comparators that the plaintiffs put forward in their complaint. And we're talking about.
I don't want to take you away from where you want to go, but my reading of your argument was that the district court's fundamental error was this is not a B1 case, it's a B3 case. Am I reading your argument correctly?
Your Honor, that is correct. That was one of many errors. There was an error regarding injury itself, which is what I'm addressing when I speak to the fact that roughly 40% of the class was not even shown to have been injured under plaintiff's own theories.
This would go to the commonality, would it, or?
As well as to Article 3 standing. That's exactly right, Judge Niemeyer.
Standing too.
That's right. This court very recently in the Freeman case said, well, look, you've got a large number of class members who are not injured. You don't have proper Article 3 standing for them. You don't have commonality. You can't proceed.
Do you have a view on the Spearley case and the sort of fight between Judge Thapar and Judge Nalbandian about whether this is really Article 3? I'm not sure whether that matters to you, but I sort of took your argument to take the strong Article 3, the Nalbandian view, if you would. Does it matter if that's wrong and the bar sort of has this right, that really it's a Rule 23 question that we're sort of addressing, which maybe is sort of a Justice Kavanaugh concurrence approach?
Judge Richardson, I think within this circuit, this court has looked to Article 3 and made an absence of Article 3.
It says there may raise Article 3 concerns, right? And that part he does say. He doesn't say it's an actual Article 3 decision, right? And you could square that, I think, pretty easily with the par's idea that when we have this type of concern, we need to be particularly vigilant in deciding the Rule 23 parameters. But that's separate from sort of going full Nalbandian, that this is really an Article 3 power.
As a matter of fact, the TransUnion does that, isn't it? In other words, standing can be Article 3, but standing also can inform whether 23 has been complied with.
Yes, I think
so that there is different standing or lack of standing to class members, then you don't satisfy the commonality and maybe...
That's right. I think Judge Niemeyer, Judge Richardson, they lose either way. It's not a great moment to me whether this court says because of the lack of standing, not that there's
Well,
necessarily
the
an
standing
Article
goes to
3 problem,
power.
there's a lack of commonality. Either way, they lose, and I think the Freeman decision recognizes that, Allig recognizes that, Stafford recognizes that, and the recent Freeman decision too. So I think that this is squarely against the plaintiffs, simply on common injury, but there's more than that. Because that lack of common injury.
I know we're asking you a lot of questions, but at the end of the day, what's, in your view, for you to prevail, what's the cleanest way to go? Is there an error on B1 versus B3? Is it standing? Is it commonality? Is it typicality? Because it seems like to me if there's an error, there's the same error in typicality there is in commonality, but that's just me.
Your Honor, it's that lack of common injury, which is fatal as a matter of standing and also under Rule 23. We think that's essential for this court to address rather than leaping to Rule 23B1. I don't think you get there without first going through 23A, and for that matter, considering Article 3. And the additional thing I want to say is that this lack of commonality is not just about lack of...
Are you an advocate of Justice Kavanaugh's opinion, solo opinion in the LabCorp case as to commonality?
He does focus on commonality there, but he also, and this comes back to what Judge Richardson is probing me on, he does so in the context where the court took the case to address an Article 3 question. But remember, the lack of common injury is not the totality of the lack of commonality here. That lack of common injury stems from all the different vintages or sub-funds that they were invested in, the different periods of time that they were in. This highly different and individualized experience is a larger part of what makes this case wrong. And so to come back to, for example...
That's a Walmart problem, right?
Exactly, Your Honor, absolutely. And Walmart, back to Rule 23, Walmart said that common injury, in so many words, is an indispensable part of commonality, and Stafford recognized that as well. I believe that in Stafford, this court said it's part of the court's obligation to find differences that actually defeat common answers. That happens here. Suppose that I'm one of those employees who on plaintiff's far-fetched legal theory, let me indulge that theory for a moment. Let's suppose that I could actually successfully show loss using other passive comparators, which are closer to the BlackRock TDFs. They're still different. There's still case law saying they're not appropriate comparators, but let's suppose I could show injury using those. I don't want my case yoked to those American funds plans, which are active funds, which court after court after court have said are improper comparators. My point is, even within the class, that lack of commonality, that lack of common investment experience results in ultimately in conflict, in differences in terms of how they want to frame their legal arguments. And it's against the interests of plaintiffs, again, indulging their far-fetched legal theories for a moment, who could bring a case based on a more reasonably comparable passive fund to say, sorry, pal, we're going to yoke you to this really tendentious legal theory. We're going to use the American funds, even though that's failed in every single court of appeals to consider it. And respectfully, we think it's important for this court to touch on that problem too. My client's been litigating this case, which has been brought on an unprecedented legal theory for 3 years now. And we think it would be best if it did not go back for it to continue to proceed based on that erroneous legal theory.
The district court seems to have a quasi-universal answer, whether it's on commonality or B1 versus B3, that there's an ERISA exception to the application of Rule 23.
ERISA is different, explains a lot of the district court decision, Your Honor, and I know that you're interested in 23B1 as well. And the key thing there is that, again, these are individual account plans, and we now know after the Supreme Court's 2020 Thole decision that I can't sue on my individual or defined contribution account plan unless I've shown injury to my account. That is essential to proceed. And the plaintiffs have continued to say that all that matters is damage to the plan. After Thole, that's just wrong. None of the plaintiffs in this class can proceed without injury to themselves. That shows that these are claims for money damages. These are people's retirements. These are individual accounts people look to on a monthly basis. What do I have for my retirement? And That's a money damages case. The Fifth Circuit said, the Sixth Circuit recognized that Rule 23b1 is not appropriate for the case of this nature as well. I'll just wrap up by saying, unless there are further questions at this moment, I'll reserve the rest for rebuttal. Just wrap up by saying, the plaintiffs have suggested that this case proceeding is well within the mainstream of other classes certified. That's absolutely false. This case is unprecedented. There's not one like it that is post-toll, that doesn't involve excessive fees. It doesn't involve a defined benefit plan. It doesn't involve a single stock that tanked, like in the De Felice U.S. Airways case. Instead, it involves vintages, sub-funds. It's as if they invested in the market as a whole. On these facts, and given the lack of injury to so much of the class, certification was legal error.
All right,
Thank you.
Thank you. All right, Mr. Miller?
Thank you, Your Honors. May it please the Court, James Miller for the appellees. Respectfully, my friend Mr. Scalia does a great disservice to the hard work that Judge Payne did in the district court proceedings below.
Well, he simply says he's wrong. I don't know if that's disrespect. That's our system.
I believe I agree with you, Judge Niemeyer, but he says he's wrong, but he also is really arguing mostly the merits of the case without discussing the fact that summary judgment's been denied and that the true merits of the case relate, as Judge Richardson identified, to whether there was a breach at a certain point in time and then later how are damages evaluated.
What do you, I will confess from all of the stuff I've read of yours, I can't figure what you think the actual breach is. Not the legal conclusion, right? You say failure to monitor, right? But tell me what you think they actually did.
Yes, Your Honor, thank you for that question. One, they had an investment policy statement that said that they had to compare the performance of the BlackRock funds to two things. One, a custom benchmark, which is really a tracking mechanism, and second, to the S&P target date index. The committee failed to meet for months and sometimes years at a time, and when they met, they never evaluated the fact that the BlackRock funds, despite all of my friends' hyperbole about the performance of those funds, the BlackRock funds persistently underperformed the benchmark that was defined in the IPS. There's case law from many...
And so is your view that the fiduciary breach is independent of the four comparators that you have raised?
Absolutely, Your Honor. And the four comparators are just placed in the complaint as a pleading matter to demonstrate a persistent level of underperformance. The other reality, and I just want to focus on this sort of 42% suggestion, that 42% suggestion that some of the class members would have been better off is related to an argument by defendant's expert as to one substitute investment. They say
But
we should
can
have...
I go back? I understand you want to talk about something else, but just,
Yes, I'm sorry.
just to wrap this up. So the question I'm sort of trying to sort of tease out of you is like, to what extent you think the injury from these four funds is actually necessary for the breach piece? Your colleague on the other side suggested that you can't have a breach without an injury, and the only way you're pointing to an injury is by pointing at these four very diverse options. Is that a necessary part of your breach story? And if so, help me understand how that works.
No, Your Honor. Under ERISA, the injury is not required for a breach. It's required to recover a loss. So, if you look at the Parker-Hannafin case, the Boley versus Universal Health case, you're talking about cases that say that you analyze breach separately. Breach in ERISA is divided into two components. One, questions of procedural prudence and substantive prudence. Here we have both. Here we have a committee that was regularly not meeting and was not evaluating the very substantive criteria that they themselves had defined as being the criteria by which the largest single investment in the plan should be should be judged. And I should note, Your Honors, that this isn't, although it's a defined contribution plan, we're talking about a plan when Genworth made certain matching contributions, those funds were automatically deposited into vintages of those BlackRock funds. And I think importantly.
So what's the best defined contribution plan case that supports you?
Well, the Third Circuit decision in Boley versus Universal Health, it was addressing somewhat different issues related to standing, whether you needed to have a class member representing each vintage of the case, but it clearly recognized the legitimacy of these claims. The Sixth Circuit's case.
Well, there can be legitimate claims, but then that still goes back not just to the 23A question, but to the underlying 23B1 versus B3 question. So what I'm asking for is the most analogous defined contribution case that supports your view.
Yeah, thank you, Judge Agee. I would point to Boley versus Universal Health from the Third Circuit. I'm fond of that case because I argued it. And then also I apologize, Johnson versus Parker Hannafin from the Sixth Circuit. Both cases that recognize that exactly these kinds of
And are
claims.
these post-Tholey cases?
Yes, Your Honor, yes. And I think Thole or Tholey, and I confess, Your Honors, I'm not sure which way to pronounce it, that I think it's important to note Thole versus U.S. Bank is a case that doesn't relate to defined contribution plans. It relates to a defined benefit plan, and in that case, the argument was the plaintiffs were arguing that certain actions have been taken with the defined benefit plan at U.S. Bank and questioning losses that could be suffered in the future. And the Supreme Court held in that case that there was not concrete injury and that there wasn't loss because there was no indication that those participants in a defined benefit plan would receive less than they were entitled to under the plan. So Thole or Tholey, whichever way I should be pronouncing it, has very limited application to this case. I also just, sorry, Your Honor.
When I go to 502 and I look at what is appropriate relief, and I'm really sort of want to talk about the B1 issue here.
Yep.
When we talk about appropriate relief, it naturally feels to me that we're describing money going into an individual's portion of the entire plan. It goes into their individual account. And so that feels like sort of individualized because if the court ordered as appropriate relief that the plan as a whole got unallocated dollars, that would seem to be wildly inappropriate to me. So can you help me understand why when I think about what appropriate relief is, that the relief is not directed into individual accounts, which suggests to me fairly strongly that B1 could not be a plausible solution for you?
Right, thank you, Your Honor. I think that's an excellent question based, not that you need me to tell you that, but
I don't, just give me an answer. Tell me why I'm wrong. That's what you really want to do.
So under the law of trusts, restoration of losses is a fundamentally equitable remedy. So if you look at Donovan versus
No doubt
Bailey-
about that, but here it goes to the individual account, not to the plan as a whole. The plan exists, and then they're effectively like sub-plans, right? Each individual account. So the relief is going to the individual account.
Respectfully, Your Honor, I don't think that that's correct, because if there was a recovery had here, the money would be returned to the plan, and then the fiduciaries would have to make a decision as to how to allocate those monies. They would be exercising their fiduciary duties. I can
Wouldn't
see
that money be gauged on the injury to each individual account? Because the counts are different. They'll have different dates of termination dates, and they'll have different compositions.
Yes, Your Honor, I think that most fiduciaries.
And so in order to determine the injury, you have to look at the injury of each account. And that would be different, wouldn't it?
I apologize, Your Honor, I didn't mean to
Go ahead,
interrupt you. I think that theoretically, what would happen in the event of judgment is obtained, as we know under TransUnion, only a damaged class member could make a claim. Most likely, the fiduciaries, in exercising their discretion,
No,
would
but
allocate.
the court couldn't do that. I don't understand how you think the court could do that. So take LaRue itself. Like, you're saying that at the end of LaRue, the district court's judgment would not say Mr. LaRue's account gets $100 or whatever it was. You're saying, no, the group as a whole, everybody, the plan gets the $100. And me as a court, I got nothing to say about what the fiduciary does with that money. Like, that seems like a wild theory to me, that what the court's judgment power is not limited to, when we're awarding appropriate relief, is not limited to giving it to the account that is indeed injured, but instead just hands it out, and then the fiduciary gets to assign it however they like.
No, I wasn't suggesting that, Your Honor. I apologize. In LaRue, I think it's an important example. LaRue is a very exceptional case because the losses of LaRue were the only losses, so that they were coextensive with the plan's losses. So, of course, if LaRue recovered, there would be either...
No, but your theory is it has to go to the plan itself before, and then the fiduciary just gets to decide, based on their fiduciary duties, who gets that money. That's what you said happens here. Like, that can't happen here. The court is the one that awards damages to the injured parties, right? That is the individual accounts. They're not awarding damages to the, plan as a whole, right? That's the very point of having to have an injury.
But Your Honor, under 502A2 of ERISA, the recovery has to occur to the plan. The losses have to be...
But it has to be appropriate relief to the plan. And the plan has an entirety and it has subparts. This is seems like to me, the very point of LaRue is that there are subparts of the plan. And so money can go to the plan by virtue of going to a subpart of that plan. And that's the court's responsibility in issuing that judgment, not the fiduciary's responsibility to come up behind the court and clean up whatever the court does.
Well, Your Honor, almost every court to address this issue after LaRue has said that LaRue does not change the fact that 502A2 calculates losses to the plans. I concede that...
But it's the question of, is it the award of, and I'll stop and I'll let my colleagues go, but the award of appropriate relief to the plan, you're saying the money has to go to the plan as a whole, the court's judgment power, right? We got certain power. We are going to award money to the plan as a whole, right? Not to the individual part of that plan, that is the individual account. In your view, the fiduciary just gets to decide however he wants to allocate that money in accord with his fiduciary duties. And what I'm saying is that is antithetical to how I understand the Article 3 power that we have to award a remedy, appropriate relief under 502 to an injured party. That is the individual account, not the sort of broad plan as a whole to be distributed by the fiduciary.
And Your Honor, I just respectfully disagree because under 502A2, it is quite clear that a plaintiff bringing a claim under that section has to be seeking losses on behalf of the plan. And so I don't disagree with you that either a fiduciary or court could direct that allocation.
But isn't that just now I will stop, I promise. Isn't that just a disagreement with LaRue? Like, you're just saying LaRue's wrong. Like, you can't give damages, you can't award appropriate relief to a subpart of the plan. And I understand there were reasonable arguments. Indeed, our court accepted those arguments in the Fourth Circuit's decision in LaRue. But the Supreme Court says, no. You can award relief, appropriate relief, to an individual account within the plan, so long as it is a plan injury.
Your Honor, I respectfully disagree with your reading of LaRue. I believe LaRue was correctly decided, and the reason that LaRue decided that an individual who had suffered losses in the plan had standing and could bring those claims was because the losses that were individual in that case, conceitedly, were coextensive with the losses of the plan, and I believe that LaRue quite clearly says that under 502A2, the relief being sought is being sought on behalf of the plan. I understand as a matter of mechanism that the allocation would then occur to Mr. LaRue, but I do think it's an important separate step, and that's why the restoration of losses under the law of trust, and if we look at Donovan versus Bureworth, which is sort of the Second Circuit leading case in terms of how to calculate damages, which is regularly followed in this circuit, and I believe is referenced in Judge Agee in your decision in Peters versus Aetna.
Which was a welfare benefit plan, which is not what we have here.
Of course, Your Honor, but in Peters, I believe that the court followed the Donovan paradigm as to how losses are calculated, and that losses were calculated on a plan-wide basis. And that was and actually, I think in Peters, which was kind of quite an interesting case, the court found that the losses accrued on a plan-wide basis, even though when you looked at the individual plaintiff, although they had been charged that fee for, I think it was chiropractic and physical therapy services, they might have otherwise have benefited because of the way they structured the plan, but that the losses existed.
The Mars plan was out the money in that particular case, and I don't want to repeat where Judge Richardson has been, but as I understand your argument, you tell me if I'm wrong. Your view, which to me seems the same as what the district court said on any number of issues, 23B, commonality, typicality, under 502A, there is a per se rule that there is no individual claim, so that any action brought under 502A would, by defined contribution plan, would have to go under B1. There could not be a B3 case.
I don't know that well, first of all, Your Honor, I think 502A1 and 502A3 provide for individual relief. 502A2 only provides for plan-wide relief. I don't know that I agree that certification can only occur under 23B1, but
Well, where's the money going to go? You win $3 million, and the judgment goes $3 million, one lump sum. Where is that money going to go in this case?
the money would go, the judgment.
No,
would-
not in this case, with the representative plaintiffs.
The judgment would be entered, as the case is captioned, the judgment would be entered in favor of the plan and the class, and then the court would have to
Well,
allocate.
the representative parties, how would the representative parties recover?
Well, the representative parties would recover, and the class would recover presumably by making claims against the corpus of the judgment. But the judgment would be entered in the name of the plan.
I understand that. I mean, the ERISA provides for this derivative notion, which I understand, but that, after you pass that thing, I mean, if it was written at a time when there were
Defined benefit plans were all it was.
defined benefit plans, and which is clearly, you have to have a derivative notion there. But we have since defined contribution plans where the individual accounts perform differently and are injured differently. And each member has a different injury. So now, we somehow, and you've claimed it, damages to the representative, let's take the two representative parties, they each have damage in their injury in their account, you claim.
Yes, Your Honor.
So we award money, set aside the rest of the class, they get money. We're not going to make it payable to the plan, are we? We
Well,
would make it payable to the individual representatives, wouldn't we?
I believe as a technical matter, Your Honor, under 502A2, because the case was brought there, that the money would be payable to the plan, but then subject to a plan of allocation, as Judge
All right,
Richardson
let's go your way.
indicated.
We make it, the check payable to the plan, but that money would then go to the accounts based on the nature of the injury the account suffered.
That would be the result in almost
But your
any.
theory is that that's the fiduciary, right? The fiduciary just gets to hand that money out, and they may have a suit, right? But the judicial power, in your view, is that it just goes to the plan, and then I'm done. And now the fiduciary has some responsibility. I mean, that means like the court is awarding money to a bunch of uninjured people, right?
Well,
And then letting the fiduciary for those folks decide which one of those gets the money. I mean, that's a wild system. You may be right. I understand that that's your argument, but that would be a wild system for the judicial power to be used in that way. And to then call that appropriate relief as opposed to wildly inappropriate relief, it strikes me as really hard for you.
Well, Your Honor, I think respectfully, I think that, the way that Judge Payne carefully and limited the class, he did not identify the class as being all participants. He identified the class as being all investors in the BlackRock funds. So I think that would be obviously a substantial limiting parameter on the fiduciaries in terms of who they could allocate, because they could only allocate to class members. And I should note that
But it's their decision, right? Your point is the judicial power has still given the 5% that didn't invest in TDF, right? The judicial power has given them a benefit. And now the fiduciary might choose to allocate it to them or not. If they did allocate it to them, they would be subject to suit. I totally understand that. But that's their judgment in your view. They get to decide.
Well, I think that the judgment would be entered in favor of the plan and the class, given the dual representative nature. So that's where the problem would be solved, Your Honor.
Well, set aside the class, because the class is at issue. Take your complaint, which is 2 representatives on behalf of the plan, in respect to their accounts. In other words, the only injury they're going to claim is the injury to their accounts through the derivative 502A plan.
Well, no, Your Honor, actually, I think that may be a very nice way to frame the question. In Cohn versus Kaufman.
No, I want to know just pragmatically what's going to happen here. We have 2 plaintiffs who claim injury because constituent aspects of their fund were not monitored.
And so under the U.S. Supreme Court case in Tibble, if the case was not certified, then Mr. Trauernick and Mr. Wright would have the right to bring a claim on behalf of the entire plan and independent of class certification. And this is exactly the issue that the Second Circuit addressed in Cohn versus Kaufman. The way that they said, the reason they said that certification under 23B1 is preferable is because there isn't a mechanism built into ERISA, as Your Honor indicated, with the creation of defined contribution plans and other vehicles that are more complicated.
Why wouldn't we, setting aside the class, why wouldn't we just enter judgment in favor of each plaintiff? There's 2 plaintiffs based on their injury.
Well, to be slightly more specific, to their portion of the trust,
Yeah.
right? Not to them individually, right? But to their portion of the trust. We would enter judgment in favor of their portion of the trust. That is, their portion of the plan. But not the plan as a whole for the fiduciary to hand out willy-nilly, but the money has to be given to your client's portion of the plan.
Well, Your Honors, if a claim had been brought under 502A1 or A3 for individual relief, that might be the case, but the claim that's been brought here is derivative.
Well, that's what I'm trying to find out. I understand the derivative nature, and the argument basically is coming down on the B1, B3 issue, is whether the derivative nature is inherently a B1. But the question I think that Judge Richardson and I are pursuing is, we understand that. That's mechanically how it's set up. But in this particular case, the claim is that these two accounts have been injured because these 2 accounts contain certain targeted BlackRock funds that should not have been included. So we're going to measure their injury by what happened in their accounts, aren't we?
Well, yes, you're going to measure their injury.
And then we're going to pay it to the plan for distribution to them.
Well, no, Your Honor, because they have the capacity under 502A2, and I think I may
No,
be over time.
they're suing for just their injury through the plan. They're having the plan do the suit. But the nature of the recovery is, the only proof you can put on is what was put in their plan, right?
Well, no, Your Honor, because under Section 409 of ERISA, you are entitled to recover the losses of the plan, which would include all of the participants. It's an inherently derivative action, so we don't believe that the
Why'd you file a class action then?
As Cohn versus Kaufman recognizes that one of the best ways to handle allocation issues and issues of manageability in light of the derivative nature of 502A2 claims.
All right, so
is
now
through
let's
the
go.
class
Let's
certification.
follow you out. These 2 are not only filing for their own, but they're filing for every other person who has BlackRock targeted funds.
Yes, Your Honor.
We have to go to each one of those persons' accounts to see how they were hurt, because there's a selection process. They could pick, one of these plaintiffs picked 3 years, targeted years, the other picked 1. So we're going to have to compute that, and the nature of their injury is different, right?
Well-
In each account.
Yes, and we have calculated that, Your Honor.
Well, I
as part-
understand. I don't care about how, I want to know how it's going to work. You're suing on behalf of everybody who has the BlackRock targeted funds. So now, basically, we're going to have to decide with respect to every one of those persons how they were injured, whether the particular targeted funds were deficient funds, right? Because if they weren't deficient funds, there's no injury.
Well, Your Honor, as I know that I'm over time, but let me answer your
No,
question.
yeah, I need to have the answer, yeah.
As the defendant's own expert, Mr. Wormers admits, this is a single decision to add these funds made on a plan-wide basis. And so it's either a breach or
thought-
not as to all class members. It's not
The
something.
class members, don't they have a right to select what goes in their plan
Yes, they do.
from a menu?
Yes, they do, Your Honor,
Yeah.
but the fiduciary act that we're describing here is the choice of the menu. And Mr. Wormers, in his report, says the choice of the target date series is a single choice. And that is why.
You're alleging that every one of those funds, every targeted date was a deficient, a breach of fiduciary duty?
Yes, Your Honor, we showed at summary judgment that every single one of those vintages underperformed its own benchmark in the IPS on a consistent basis, to go back to Judge Richardson's question. But the reason that 23B1A and B are so appropriate here is because the question at issue is, was there a breach? That question is common to all class members because only one investment can be put in there on the menu.
It's common, but,
And
you know,
then-
at bottom, we're talking about real money. And the real money is money that is held by these beneficiaries. And each beneficiary has been harmed in a different way. And the money's ultimately going to get to these people. And so you're saying we're going to have a class that is going to decide this issue for everybody, and we're not going to let any class member opt out or even receive notice of the litigation.
Well, Your
We're
Honor-
going to mandate that every one of these people has been hurt because they have some of these BlackRock plans, and all of them in different configurations, different years, every 10 years or whatever they are in there. Does that work?
Well, yes, Your Honor. One, I should say that, we regularly provide notice in 23B1 cases, and there was no request
but
here,
it's-
but, so I just wanted to
No,
put
but
that
it's
aside.
it's
but-
basically, somebody may want to opt out and said, my particular plans did very well. As a matter of fact, my particular plans defeated the other plans that are in the thing, and I like it. I don't want to participate. What about that beneficiary?
But, Your Honor, the relief that's being sought here is both the restoration of the losses to the plan as well as the declaration that there was a breach. And if that fund is
Is there a
eliminated from
breach
the
without
menu.
injury?
There is a breach of fiduciary duty without injury, to go back to Judge Richardson's question, but whether or not there's a loss to the plan is a separate question, and losses are calculated on an aggregate basis. This is recognized in Tibble versus Edison. Every U.S. Supreme Court case that's been decided under ERISA in the last half dozen years has been a 502A2 class action. So it's not, it's not an outlandish action that we're pursuing respectfully. I think that it is important to focus on the fact that the single decision to add the target date suite to the menu is the claimed breach. If from both 23B1A and 23B1B perspective, you have profound issues if you have different decisions made as to whether or not that's a breach or not.
I
Your
think
Honors-
we've gone over
Yep.
quite a bit
Thank you
here,
very
but
much for your
it's-
intelligence.
You've been helpful, thank you.
Thank you for your indulgence, Your
Yeah,
Honors.
Sure thing. All right, Mr. Scalia?
If I could, I'd like to come back to this issue that has taken so much of the panel's time and first address a threshold question or two. One, I don't think we heard from plaintiff's counsel at any point on this very important question of the absence of a common injury. Setting aside theories of liability, what have you.
Well, I didn't get around to asking it because it didn't seem relevant with respect to his answers. I mean, but it seems to me every beneficiary suffers a different injury. I mean, it's depending on the composition and nature of what he selected or what was put in by default.
Well, that's right, and it's not enough to say that there's been an injury to the plan as a whole, and Thole answers that question for us. There has to be individualized, account-based injury. If I don't have that, Thole says, I'm out of court.
So what do I do if I just say that, like, the only plan that's left here, this is hypothetical, I acknowledge, is the American funds? And in that world, we could then say, and I understand you think it's not a proper comparator, but I'm on the Rule 23 question, not the 12b6 question. Then we would have an injury. It's not the same, but we have an injury to every class member then, right?
I don't know that you actually have one for every class member. I think what you have is every vintage during this cherry-pick period of time.
Because somebody could have bought it at a particular
it's
time.
still, you still have that problem. I want to come to Judge Agee's question, a question that I always like. What's your best case? What's your best case? You were told the Boley case. You were told a Johnson case. I don't know what that is. I don't think it was cited. You were told Boley, Third Circuit case, that Mr. Miller handled. That is one of the other kinds of cases that I mentioned, an excessive fees case where allegedly all accounts were charged excessive fees, so all accounts had the same problem. Here's what the Third Circuit said. It said, the nature of these claims makes intra-class conflicts unlikely. It is difficult to imagine class members who have benefited from or are content to pay pointless fees. That's a completely different issue than individual account performance, such as in a case like this. When that's his best case, he's got no useful precedence.
Let me ask you, as a factual matter, is there a fund apart from the individual beneficiaries' accounts?
I don't believe as a practical matter that it's kept anywhere. It's held in trust for individual accounts, but I don't think there's actually a corpus. I think it's bank accounts and the like.
Are there funds that are not allocated to any particular account?
I don't believe there are funds that are kept somewhere separately. But I'd like to conclude with just some observations on this, because with all respect to Mr. Miller, who's very effective in this area of the law, if I am a Genworth plan participant, I want somebody who's here to represent my account. I don't want somebody who tells me, oh, sorry, Mr. Scalia, yeah, I'm here for the plan. I'm here to maximize for the plan. At page 4 of his brief, Mr. Miller says, all class members share the same interest in maximizing the return for the plan. If he told me that as his client, I'd say, I'm sorry. I'm here for my personal retirement account. I want what Mr. LaRue wanted, and I want a lawyer who's going to get that for me. It's as if Mr. Miller is saying, like Brandeis, I'm the lawyer for the situation. I want a lawyer for my account. And what LaRue tells you is that you have the right to do that, and Thole tells you you must do that. There was a day after Russell where the thought was there must be injury to the plan, and maybe that's enough. And maybe individual account injury doesn't count. LaRue said, no, it does. It's an injury to the plan affecting the account. And then finally we have Thole. Thole says, you have to have injury to the individual account. And the plaintiffs have never had an answer to Thole. You barely heard it in their brief. They mention it once in a footnote. Even though we cited it 8 times, that case has changed how these cases can be litigated. It's one of the fundamental points of distinction between so many cases that Mr. Miller's relied upon and what this court should properly do here.
Let me ask you, is the fact that the individuals have a choice with respect to what's contained in their accounts play any role in this discussion? In other words, each beneficiary gets to make a choice from the menu and gets to, I guess, even a portion where his money goes. Does that have any play in the class action issue?
I think, Your Honor, there are certain defenses that can be made based on that ability that plaintiffs have. What's relevant here is that they have those accounts and that they can make decisions about them and pursue those accounts' interests for themselves. But we're not interposing a defense based on the choice they exercise.
Okay.
Because
If I
the
could,
concern is what you put on the menu. I mean, that would be you're not making your colleague's argument for them, but what they put on the menu might well sort of be an error or a breach of fiduciary duty in some other context.
yeah, and what they chose here was one of the most highly rated funds. And I could just conclude with respect to the Bolia case, again, with which Mr. Miller handled. That case involved a firm that had an actively managed fund, and it got sued for having an actively managed fund because of those excessive fees that I mentioned. Partly because of litigation like that. Clients like Genworth have said, I'm going to go to a passively managed fund. I just don't want to deal with that litigation risk. What happens next? One of the world's highest rated passively managed funds is adopted by Genworth and 10 other companies, and they all get sued for what? For not having an actively managed fund. We can't manage retirement accounts in this way.
Can I ask a follow-up to the question that I asked your colleague? Is how we would manage in this context to order relief? So forget the class action. Just imagine we've got these two plaintiffs, and they prevailed on this theory. Just accept it as a hypothetical. I know it's hard, but just accept it. What is the relief that would ultimately be ordered? And I'm trying to figure out, like, what is the relative role of the judiciary and the relative role of the fiduciary? Do you have a view as to whether it is the judiciary that would award the appropriate relief to their two individual accounts, or whether that relief from the judiciary would go to the plan as a whole and the fiduciary would then allocate it to the accounts? Do you have a view about which way that should work and why?
Your Honor, it's an interesting question. I looked into it in preparing for this argument, and I couldn't get a clear answer. And I think part of the reason is because of the settlement pressure a case like this exerts, they end up getting settled. I think the bottom line is the same, regardless how you get there. It has to be money into individual accounts because that's what their individual right is in their account. I doubt that would be written into the terms of a court order. John Doe gets X, but I do think there would need to be an allocation process agreed upon by the parties and presumably approved by the court, whereby somebody responsibly ensured that the individual people got what was their right, rather than there just being some sort of brooding relief to the plan as a whole, which is not how the individual class members would want it to operate.
All right, thank you.
Thank you.
All right, we'll adjourn court for the day and come down to Greek Council.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.